Bom dia a todos. Começando hoje mais uma reunião mensal do STEP Brasil. Hoje com um tema super interessante na perspectiva dos Estados Unidos. Nós temos o Ivan Sachs, que é o head da área de Private Clients do Withers em Nova York. E hoje o Ivan vai discutir com a gente aqui as perspectivas do Transparent Act nos Estados Unidos e os impactos que isso pode trazer para todos nós que lidamos com a jurisdição americana. Então, em nome do STEP, eu queria agradecer a presença de todos vocês, agradecer a disponibilidade do Ivan e tenho certeza que vai ser uma discussão muito rica. Como sempre, o nosso objetivo aqui é fomentar a discussão, então, por favor, fiquem à vontade para mandar as perguntas pelo chat. Eu e o Norberto estamos aqui com o objetivo de moderar esse painel, trazer as perguntas de vocês e fazer com que essa experiência seja a melhor possível para que todos nós tenhamos aí o melhor dos conhecimentos do Ivan. Ivan, thank you very much for your presence here with us today. It will be a pleasure for us having this opportunity to see and know with you and learn with you, and it will be very good to have discussions on this topic that is a hot one for us that deal with planning involving U.S. jurisdiction. So thank you very much. The floor is yours, and go ahead. Thank you very much.
Terrific. I thank you and thank Norberto and for hosting this. It's a pleasure to be back speaking with Brazil STEP. I may not know this, but me and my partner John Ritchie's at the time spoke at the first Brazil STEP chapter meeting some years ago, and it's great to see how Brazil STEP has flourished under your leadership and is a really important chapter. I think as we have expanded from the common law and really added top senior practitioners in Brazil and Latin America to what we do at STEP. So what I have been asked to talk about today is the advent of and why it's interesting, I think should be interesting to you, is this is really the first beneficial ownership registry in the United States. And, as you know, we started quite a swirl in the world with the creation of FATCA and the beginnings of cross-border reporting from that vein. But that was really conceived from a U.S. point of view is quite a unilateral thing. We have agreed to some mutual exchange, but it's been little done. And it started a process, however, that the end of which we have not yet seen. At first, I thought that this Corporate Transparency Act was not a very big deal at all. Because we have the U.S. has long needed to have a basic ownership registration for companies, and has really been quite behind the civilized world in respect of that. And given the importance of U.S. companies in structuring transactions, and from a standpoint of anti-terrorism and anti-money laundering, quite apart from tax, this is overdue. It does focus on the structure, the designation of who has substantial control and beneficial ownership of companies. Why it's not such a big deal is that it is a private registry. It doesn't bespeak public access to the information that is to be reported under it. There's no automatic sharing of this information with other countries, other jurisdictions. And FinCEN, network within the Treasury Department that is responsible for the oversight of this and actually the elaboration of the systems that are going to take quite a bit of time to develop to administer this is a very under-resourced a branch of our government. So it's not going to be able to do much with this info for some time to come until the computers get better at talking to each other. I think the thing that was, of course, of great interest to all of us in the private wealth area has been that it would not require a pure beneficial ownership designations, registrations for trusts. So we breathed a bit of a sigh on that from a standpoint of our clients' privacy interests. However, this is going to be quite fundamentally affecting the way we think about convenience, cost, and compliance risk, as well as disclosure for legitimate interests that are setting up companies owned by trusts and corporate and partnership arrangements generally. So it's going to be very important for us all to understand this really well and advise clients about it. And I'm happy to be, going through it with you today. It's very new. The act itself was passed back in, let me see if I can go to first slide here. Hold on a second. It was initially passed as part of the Anti-Money Laundering Act of 2020. And as I noted, it's administered by a Department of the Treasury, which has some significance, and it's Financial Crimes Enforcement Network, which we speak of by the acronym FinCEN. But then regulations were published about a year ago, in last December, and there was a huge amount of commentary on this. Bear in mind, there are over 30 million companies, LLCs and corporations registered in the United States, and at least a couple of million are registered new every year. And this is going to affect every company. Not necessarily will everyone have to register. I'll get to that a little later, but every company has to consider its reporting obligations with respect to this. And it is intended to require registration by the small companies. The companies that are not already subject to regulation by being, large corporations, SEC registered corporations, nonprofit regulated corporations. So companies of size and subject to, public companies will not end up having to register for this. This is intended to get at the stuff that we do, forming small holding companies for private wealth and that sort of thing. So there's a lot of them, and so the period of comment led to about 270 comments, and the FinCEN actually took a number of them to heart. So the final regulations were issued on September 29th, just a month ago. And you'll see that the date on the first page of my presentation was October 20, because we're continuously updating this information at the moment. And this is sort of our latest, presentation draft. Where we are now is we know a lot more than we did before, and a few important things that the final regulations did were, among other things, initially the proposed regulations were going to require the reporting of the applicants, meaning in some cases the paralegal or corporate services agent and the lawyer who directed them, who filed any company in existence in America going back forever to be registered as part of this process. And the final rule eliminates that and will require the reporting of the applicants to be registered starting from, this act goes into effect January 1, 2024. So its effective date has been put off to a year. So we have some more time to get adjusted to this. And 2023 is going to be an important year for preparing clients for that, because once you enter the reporting stage, you have to do it within 30 days of the formation of a company, et cetera. So in this discussion, I'm going to address what is the definition of a reporting company. The core of this program is to put on the obligations on the reporting company itself to register its the corporate applicants, the people who either have substantial control or beneficial ownership of that company, and require certain specific information to be disclosed about that. And where it gets interesting and quite subtle is if a trust and trust companies are directing trusts which own these companies, then what has to be reported about them. So I want to talk about that a little bit for our interest in, specifically. And what is the timeline, penalties, and privacy protections for that? So first, there are two kinds of companies that do have to report: domestic companies, including any corporation or LLC or other entity that is created by the filing of a document with the Secretary of State or a similar office of government. So it doesn't include, for example, general partnerships or things that are just formed, and trusts, which are just formed by private agreements. We don't register those with a state in the United States. Foreign companies which register to do business in the United States will also have to register under this program. So if you have a client who has a company that is, for example, a foreign company that owns even a US apartment or residence, and your US lawyers will advise that it should register to do business, or is required to either get a bank account where the bank may request that, or if to sue or be sued, and therefore protect assets. Foreign companies, sometimes they don't do it when they could or should, but if they are registering to do business in the United States, this registration requirement will apply to them. Excluded are companies in highly regulated industries like banks, broker-dealers, et cetera, public utilities, large operating companies, which is relevant to our clientele in the private wealth industry, certainly, because it's only companies with more than 20 employees and gross receipts of more than $5 million, as reported on a U.S. income tax return, and have a physical office in the U.S. So, serious doing business operating companies will be exempted from this. And some of our clients' family offices may be exempted from this. Tax exempts, Section 501c, private foundations, public charities, publicly traded companies and government entities, and certain things called pooled investment vehicles, which I won't get into, but hedge funds, private equity funds, et cetera, if they're subject to regulation. So a reporting company is an entity that is created by filing a document with the Secretary of State. As I mentioned, it wouldn't include general partnerships or trusts. It also doesn't include what we call sole proprietorships, where an individual is doing business as with a trade name but doesn't form a company. Directed trusts, administrative trusts are mentioned here, discretionary trusts. We'll get into trusts in more detail later. So apart from reporting, determining whether you have a reporting company, the other difficult questions are going to be what constitutes a beneficial owner for purposes of reporting, what constitutes someone, let me stick on this. Beneficial owner, unfortunately, in my view, is demonstrating, the definition is demonstrating the bleeding over of anti-money laundering law to words and vocabulary that particularly we tax lawyers take very seriously as meaning something different. And is really, if you are familiar with CRS and other AML, they constitute as a beneficial owner people who may be professionals or have no economic interest in the structure, but exercise substantial control. And that is because the focus of this is on anti-money laundering, terrorism, and others, and the government wants to know who's exercising the control. So the definition of a beneficial owner is an individual who directly or indirectly exercises substantial control over the entity or owns 25% more or more of the ownership interest in the entity. Both of these are ambiguous, and it will take a long time for some clarity, some further clarity to be developed on them. But there is a lot of commentary now in the regulations that were finally issued to inform us some more of what they want here. The other people that have to be reported in this scenario are, as I mentioned, the people who just absolutely file the papers to register the company. So the person who files that formation document and his or her immediate supervisor. So for example, in my firm, that would be if I ask a paralegal to form a company on behalf of the client, then I'm directing the paralegal. I have to be identified and my various pieces of identifying information filed, and so does the paralegal. In foreign companies, the person who files the registration documents to do business in the United States and his or her immediate supervisor have to do that. And as I mentioned, a very big deal that was argued and commentated on significantly and resulted in some surrender on this is that company applicants for entities that were created before next January, January 1, 2024, will not need to be reported. So we don't have to go back to those 30 million companies that were created, before now and do this, which would have been a nightmare. And also we still have a free bite at the apple for the next year, as far as this issue is concerned. On the beneficial owner side, there are some exceptions as well that are interesting. For example, minor children are not individually identified as beneficial owners, but the parent or guardian has to report on their behalf. Nominees are not considered relevant unless they have a different role exercising substantial control. So certain intermediaries, custodians, or agents acting on behalf of other principals are not treated as beneficial owners. They want the name of the actual beneficial owner. Employees of reporting companies whose control over or benefit from the reporting company is derived solely from their status as an employee, which is a lot of legal gobbledygook, but basically senior officers, which are delineated, chief executive officers, general counsel, those are some people that are enumerated as being senior officers of a company deemed to exercise substantial control, whereas mere employees of the company that are executing those directives are not. And then a person whose only interest in a reporting company is through a right of inheritance are not considered beneficial owners, but where this will come into play is within 30 days after an estate being settled, if there is a transfer then of true beneficial ownership, that will require an update of the registration to include the inheriting person, assuming they're an adult. And creditors with claims on a company can be substantial, but they're not deemed beneficial owners under this arrangement. The definition of substantial control. Okay, this is an individual. So apart from these kind of enumerated senior officers and people that functionally serve as senior officers, it's anyone who exerts authority over the appointment or removal of a senior officer or a majority of the board. Someone who directs, determines, or substantially influences important decisions made by a reporting company, which is a very vague, broad concept. And this is where, as I go through this list, if you think about the role of protectors, appointers, enforcers, some of the things that we do in common law trusts to create checks and balances, and we'll come back to this at the end slides here, is how are we going to decide who in trusts that own these companies has to report is going to be interesting, because somebody who has a substantial influence on a decision regarding the sale, lease, or transfer of a company's assets. So people with investment control, reorganizations, dissolutions, or mergers. Someone who has substantial influence over, investments, dispositions, the selection of an office, compensation, and amending corporate governance documents. And then, as I say, these are not exclusive list of things, because there's a catch-all: any other form of substantial control over the company. And these are not, needless to say, I wouldn't be spending so much time on this if there was just, you only had to identify one person, and then you didn't have to identify the others. You have to identify every person who has any of these things in the registration. So who's a beneficial owner? Who's really a beneficial owner? In other words, setting apart the substantial control powers, what about people with ownership interests in the equity or capital and profits of the company? So the regulations say that those ownership interests can be direct or indirect. An individual can own an interest in a reporting company through a trust or another form of agreement or relationship, like a contractual arrangement, joint ownership, and via or through, a nominee or custodian. Some of the issues that were debated here, for example, it's interesting that the government is already attentive to these things that we would consider, is complex structuring, for example, with option rights. If you structure a company where you effectively have the right to take control, but you don't take control because you hold a freely exercisable option, they mean for that person to be reportable. They say so in the regs. So contractual rights and things that are effectively have the right to assume control of an equity interest are to be counted. And as I mentioned, an individual who holds an ownership interest by a trust, such as a trustee with authority to dispose of trust assets, beneficiary who's a sole recipient of income and principal, or principal, and has a right to demand that, so that can be quantified. And of course, a grantor or a settlor who has a right to revoke a trust. So a revocable trust, it would be not possible to avoid reporting the grantor if he owns if the trust owns a U.S. company. You'll notice we didn't say here a directed trustee or a purely administrative trustee. which is increasingly popular in the United States because they may not have any of these powers. One thing that's ownership of note here, if you want to try to remember this, is unlike some of the European and international rules, this requires reporting if you own at least or 25% or more, whereas some of the other rules under which we report internationally are for more than 25%. This one is 25% or more of the total ownership interests that an individual owns directly or indirectly, calculated based on the present value, including any options treated as exercised, as I mentioned. And for entities that issue capital and profits interests, one is required to try to calculate that and determine what's the right answer here. It will not be easy in every case with complex corporate holding structures. And this also speaks to the ownership as being voting power or value. So under those rules, we have, as I've said, we have to report the corporate applicants who file for these LLCs or the companies, and we have to report if the company meets that set of definitions, and then we have to report all the people who have substantial control or beneficial ownership of 25% or more. What information needs to be reported for them? Is basically the legal name of the company and any trade names, its principal place of business. It can't use a P.O. box. You have to put the address of the reporting company where it claims to do business. And that's supposed to be an address in the United States. So if it's not a domestic company, then the address of the primary location in the US where the company conducts business. As we know, for holding companies that we often create for wealth and investment structures, this is not always the easiest thing to decide, but you have to pick something. And I don't think it's going to be as easy in the future to just pick the address of the corporate service company in Delaware or Wyoming or wherever you might have formed a company, because they're going to be looking for a doing business address. And then for a domestic company that pays tax, of course, an IRS issued tax identification number. Foreign reporting companies will need to report their state of registration in the foreign country and their foreign unique identifying number. It's not necessarily a tax number, but a unique identifying number. The beneficial owner and the company applicants, the individuals here, report their full legal name, their date of birth, their residential address if they're an individual. So, and if they're a company applicant, if their role in this exercise is that they're doing something in their official capacity rather than as a beneficiary, then they report their business address. And then an identifying number. Again, it doesn't have to be a tax ID number, but it could be something from a passport, a driver's license, or other ID, and an actual image of that document. So you can see that the United States in this respect is beginning to approach some of the customer due diligence requirements that banks or the world round now comply with in terms of asking for passport copies and getting an image and that kind of thing. So what I thought would be just interesting here is to kind of take a look at a picture or two and get away from all the mind-numbing statute stuff and sort of think about how does this work its way through with some of the kinds of private wealth holding structures that, you know, we at Withers certainly are often involved in for clients in Brazil and in other places. In this case, this illustrates a generic structure that might involve the use of a private trust company, whether in the United States or abroad. But we can substitute, you know, commercial trust companies and banks here and individual trustees and explore that as well. But in a case like this, you have quite a stack of entities. And if you see the bottom tier, which is the initial reporting tier that we're imagining here, you have 4 potential reporting companies and a whole host of potential actors, from the applicants who would form these entities, the managers of them, the partners, general or limited, boards of directors, officers, administrative service providers. And those are the potentially reporting companies, yes. And then we have family trust with various functionaries in a sophisticated family trust. There may be multiple trustees, protectors, or a committee of protectors, distribution and investment committees, family beneficiaries, etc. And then you have its substantial controller, the private trust company, and the officers who may be required to report, or as well as enforcers or others, and the purpose trust, which in some jurisdictions we use to own the private trust company, and of course on the right, the beneficial owners. I'm just going to skip over to the next one. There'll be a quiz now, and I'll ask you who has to report what. No, just kidding. At the bottom, you know, we may consider using things more like general partnerships, because a general partnership is an agreement to form a partnership, and it can file returns and do all the things it needs to do, but it doesn't register with a state. It's a private contract. So general partnerships don't impart limited liability for the investments, but if all you're investing in are investments that are limited to the amount of the investment, sometimes that can be oversold, the benefits of limited partnership. So general partnership, no. Sole proprietorships, no. Limited partnership, yes, that is formed with a state certificate. And that's usually what we typically use if we're forming a partnership today. And the big one will be, you know, because it's so prevalent in the United States and convenient today, LLCs, limited liability companies. The acronym there, SMLLC, means single member LLC. So whether a partnership or, I mean, if it has multiple members, it's a partnership for tax purposes. If it has a single member, then it's sort of an ignored entity that the tax aspects of which go up to the family trust. That would be required either way, regardless of its tax status, to be a reporting company. And so would the corporation over on the right, a true, you know, Sociedad Anónima, a corporation. So then if we imagine that those entities are that have identified are reporting companies, the LLC and the corporation and the LLP, the persons who file to form them, it's pretty much seems like it's likely to be limited to 2 people. Can file the reports on their individual details. And then the question is who beneficially owns these and who has substantial control of them. So we would have to look to the senior manager the person who's appointed as the directors of this. And, you know, those of you who are in banking, commercial trust companies, corporate service providers, who might, you know, in the past take the roles, and certainly will be asked to take roles as directors or inspirers of these corporate formation services, will have to consider you know, your reporting roles, and it could, I think it could have some impact. I don't think that there's any reason not to file, but it's just an additional compliance burden. Now, where as I say, where I think it gets quite interesting is in the next phase, where the challenge to file a true and complete version of these reporting requirements will be complex for a while, and where it will also influence elements of advice, because the trustee who has discretion is likely to be treated as in substantial control of the company that has been formed there, because they have you know, the right to exercise discretion over substantial decisions of the trust. This is a little bit of a starter chart that we are developing, along with checklists and things for advising our clients, including, you know, trusts and fiduciaries, as trustees and fiduciaries, as well as, of course, beneficial owners. And we will be continuing to develop this kind of a grid as we, you know, expedite on this. But as I mentioned, you know, we would see trusts that themselves are not a reporting company because they're not formed by the state, and a directed or administrative trustee who's not exercising substantial control, I'm up in the upper left box here, would really not be within the purview of these requirements today. A private unregulated trustee, like the private trust company that you might form in some of jurisdictions in the US, particularly in the West and Alaska. The trust wouldn't be a reporting company if it's a directed trust. And if the trustee is not exercising substantial control, it might not have to report. But of course, most of these private trust companies would have family member or family functionary involvement and would be exercising control. Otherwise, why create one? On the discretionary trust side, the trust is still not a reporting company, but the trustee is exercising substantial control, and therefore the trustee itself would be reported on that basis. And in an unregulated context, the same is true. So in each case, the beneficiaries may be beneficial owners if they're the sole potential recipients of income or they retain withdrawal rights. And if you think about this, so typically today in, you know, we tend to favor in multi-generational planning of great wealth discretionary trusts that are very broadly discretionary, but oftentimes the settlor retains, you know, control during their lifetime, and then will want to pass on some elements of that control to family members. Certainly the right to remove and replace the trustee and others to ensure accountability will often be the case, while leaving the disposition of interests discretionary so that one can manage the tax efficiency of different countries and things, and not have to over distribute, and the asset protection benefits of not having mandatory distributions. But this will be a new element to consider with respect to that kind of mandatory distribution. Let's say, for example, that you have a scenario where you want your child to begin to receive all of the net income of the trust when they're 21. So no distributions before 21. When the child reaches 21, they should start to receive the net income annually and principal in the discretion of the trustee. Well, if they're the primary beneficiary of that single trust and they are entitled to the income, then within 30 days of their turning 21, someday in the future, somebody has to remember to register that person as a beneficial owner of the trust. So that's why I say some of these rules are not such a little deal, because they're going to put quite a compliance burden on really understanding the trust and focus our attention on how many people do we really want to give controlling authorities that require not only reporting but updating. I'll get to that in a minute. There's some interesting comments in the regulations. And this one has really quite intrigued us, because we're thinking about what it may mean for planning, which is if you're an exempt entity, like a trust company that's large enough or that's regulated, so you're exempt, you don't have to be reported. And if one or more of those exempt entities has or will direct the interest in a reporting company, and there are individuals who own that exempt entity, then this statement says that those individuals will not need to be reported, the owners of the exempt entity, but the exempt entity itself can provide its information in lieu of the substantial owner information about its individual owner. And these are things we're going to be thinking about, both with respect to existing entities and the requirements, but particularly in terms of planning possibilities for those who are trying to maintain their privacy for legitimate reasons, and as well as commercial interests, where people will like to limit the number of reporting incidences that they have to make. So on the back end of this, I just want to go through a little bit how this owner information is going to be submitted. A reporting form is going to be provided for this. It hasn't been issued yet. People like us, people who are in the business, who are going to do this a lot, will individually, we will go and get a FinCEN identifier. We'll lodge our information, my birthday and my name and my address, and I'll get a FinCEN identifier number, so that if I'm putting myself in the way of directing people to form companies, I won't have to go through filling out the form anymore. With all the details. I'll simply supply my FinCEN identifier, and they'll have my information on record. And so, and I assume, those of you associated with commercial trust companies and things, you may find that you're doing that the same if you have U.S. Arms involved in that. Now, each report will contain a certification that the information is true, correct, and complete. A lot of comments by lawyers were and organizations were saying, you should give us a to the best of our knowledge type of standard after due diligence, due inquiry, that kind of thing. But they declined to accept that. They did make comments that if people have made a good faith effort and they have done everything they can, they're not going to suffer criminal penalties. But it's still quite a statement to say that to a form that may have to go up several tiers, where you don't actually have the information potentially about your beneficial owners, right? It's the reporting company that has these obligations, not the people who are, say, beneficial owners. So you have to get that information and report it as true, correct, and complete at the company level. So again, winding down here towards the end of my comments, domestic companies and foreign companies registered on or after January 1, 2024, and you have to file within 30 calendar days of the formation or registration being effective. Companies formed or registered before January 1, 2024, their initial report isn't due for a year. So if pre-existing companies, we have some time. If there is an incorrect report and somebody becomes aware of that, you have to make or there's simply a change in ownership, a transaction that transfers the ownership of the company, or a change in its status. Like I referred to in that quirky example, a beneficiary becomes an adult or attains who is a substantial owner, attains that status. Then you have to make a filing to adjust your registration within 30 calendar days. I mentioned where you have a deceased beneficial owner, you have to file, so you have an estate. You don't have to file during the period of the estate, but when it concludes and there is a new ownership following the disposition of the estate, then you have to file within 30 days. And when minors attain majority, if they're substantial owners. So the penalties for willful violations of this, the civil penalties are up to $500 a day per report. And, civil penalties would apply in most circumstances of, good faith attempt or non-willful violations, and criminal penalties for willful evasion of this, fines up to $10,000 per report, and imprisonment for up to 2 years or both. Both the non-compliant beneficial owner and the reporting company will be subject to civil and criminal penalties for non-compliance. Exactly how a reporting company goes to jail, I don't know. These, whenever there are criminal penalties against the company, it's a quirky situation. But so while the reporting company has the obligations, the individuals are in jeopardy. There is a safe harbor for correction of violation within 90 days of filing an inaccurate report, which is, formally speaking, within 30 days of being advised that you've done it inaccurately, and within 90 days of the filing of the inaccurate report. And I think that some of us advisors will be in the position of recommending to clients that we now audit the arrangements that they have leading up to these deadlines, and a legal audit is what I mean is, or you guys in your roles as advisors, whether as lawyers or not, get clients to review U.S. company structures so that they have adequate, positioning. And if then in the future, that will be an ongoing thing to raise with new clients, because we can help them discover these inaccuracies, and upon discovery, try to correct them promptly in order to avoid these penalties. So where are we going toward the future? I mean, I think obviously the big question that many of us in the international world and with cross-border stuff and concerns about hacking and privacy and selective persecution and stuff, where the U.S. is always a bit obtuse to this issue in other countries where wealth has more reasons to be concerned about unauthorized disclosure. Is I think part of the big question for the future. As I mentioned, there is no public access, but some of the details about what the access rules will be are yet to be published. What has been indicated is that FinCEN can disclose this information upon receipt of appropriate requests from other federal agencies of the United States government, and state and local agencies, subject to court orders, that are pursuing, police information or civil investigations. And
Ivan, quick question on that topic.
yes.
If another government agency requests for something like this, can it be to fund corroborate with an investigation being requested from another sovereign nation?
Good question. I would say that it is possible because through through mutual legal assistance treaties and tax information exchange agreements that we do have with other countries, not with Brazil, it is possible for a foreign government or a foreign court to appropriately seek access to cooperation from our government and our government to provide it. So I think for example, if you read the preamble to this, a lot of it is about getting after the Russians, getting after, international criminal conspiracy and terrorism. And, that is the focus of it. And I would not have a serious question that if a foreign government is pursuing, an Interpol warrant and is looking for, that a US government agency with access to this will not give access to that company information. I think we're still quite a ways away from this being utilized for tax investigations of foreign countries. The United States is not an enthusiast in that at this time.
But not driven by tax investigations, but any other kind of investigation. In any country. Because you mentioned double tax treaty with other countries, but if it is something that an information that deemed to be worthy sharing, and that the nature of the questions that one might have upon analyzing things like that is, you mentioned the preamble. This is focused on tax, and so let's say that is a tool that is a unitasker is going to do this. But then you start finding other uses for this tool. And I think this is something that us as advisors need to be, to keep an eye on it.
Yeah, absolutely. I mean, there's a lot of times where we form holding companies for trusts. We don't necessarily need the holding company. There is, shifting tax efficiencies in the United States, but for things like whether to have a corporate entity for the ownership of a US piece of real estate versus having a trust own it directly. The trust needs to be irrevocable to protect the Brazilian from US estate tax, but there doesn't necessarily then need to be a holding company under there. So there will be things that we can do for some of the conventional structures that lead to volumizing some of these LLC creations more than necessary. And then in other ones, we're going to, have to at least advise. And the thing that I think is unfortunate from my strategic planning point of view is I like to have watchers for the watchers. We all, checks and balances. The grantor retains these rights. The protector has these rights. The trustee has these rights. The investment manager has these rights. But I think there's going to be obviously a little bit of conditioning on that now to keep that from getting flabby, because the more people that you have, the more people have to be reported. And when they change, you have to remember that you have to go and report the change. And that is a lot. And then, as you say, all those people will ultimately, I think, be subjected to risk of broader disclosure than they would like. Until the computers, The infrastructure bills and that have recently been passed in Congress in the United States have supplied some new capital to the IRS to update its technology, which is way out of date last century. And I think that the risk of more disclosure is going to come from more integrated technology, which the United States is still quite behind on. There is a new system that has to be created, a new database that has to be created to hold all this stuff. And I think that's probably part of the reason that some of this has been put off for a year. And it's called by the lovely name BOSS, the Beneficial Ownership Secure System. Sounds great. So they, as the secretary,
BVI also uses the same acronym for one of its filings, and also I was just taking notes here to make a comment that if there's anything adjusted in the structure, you need to adjust the BOSS filing system, which makes more different for us service providers to keep mindful when we're doing this, and you're always as strong as the weakest link on your chain.
Absolutely. So I mean, they're professing that they're going to make it secure and use information security methods appropriate to protect non-classified information at the highest security level. Okay, so yeah, what else is next in the United States in relation to some of this is, it's worth mentioning these National Defense Act that passed this a couple of years ago. Subsequently, in that reauthorization bill, they passed the House passed the Enablers Act, and that is not passed in the Senate, and its prospects are questionable there. But that's basically a act to try to get at the gatekeepers, the lawyers, accountants, financial professionals, and stuff that advise on structuring and ensure that they're not advising bad actors. And so, really, to try to expand the CDD rules, the customer due diligence rules that apply under our AML now to financial institutions, so that we have to more adequately identify our clients and things like that. And again, a law firm like Withers, we're not troubled by that in the sense that we're an international firm. We adopt a global perspective on this and long have with respect to CDD. But the U.S. rules are changing, and the enforcement of that. And then, of course, we have OFAC sanctions and searching inquiries now going on, and quite troublesome questions for trustees about what they're going to do if they have they're stuck holding assets for in some cases innocent beneficiaries of Russian ancestry or Russian assets, and who have nothing to do with the oligarchs. So that right now, our rules prohibit listed persons from being advised. But there is concern amongst trustees about the longer term, what to do with anything that is incidentally associated with Russia, not related to corrupt oligarchs.
One thing on that, right? As having had the personal responsibility of trustee in the past, we would be taught by the staff trainings that we should seek legal advice if we were in question on something like that. So let's say that I have here somebody that could but could not be related to one of those things. How far do I need to go up a family tree to see if this is a person that I should be considering and seeking a legal court decision if I could or could not service such structures. And I have another question also in relation to obligations, because some of those obligations are new. And not too long ago, certainly the last time that we were together in New York, we didn't have any filings to do for U.S. Entities such as an LLC. You had an LLC and you was there and you didn't inform anything to anybody in any circumstance. And a lot of clients are still living in that period of time, or they might be. What is the changing a little bit from this topic on the presentation, but still on the obligations? If a structure is not filing its obligations, what does that structure need to do? Like if they didn't file the 5472s, can they go back and negotiate with the IRS, such as the incidental American that didn't know how that he had to file income tax in the US and it's not on the grid yet, and he'll say, well, IRS, I have here a client, he's not filing. If you're not investigating, can we cut a deal for him that he can come clean on this? Is this something that is happening on the obligations?
Well, it's a complicated question and a complicated answer, and it has to. The answers are very specific to specific situations, but a few general points that I would make. If it comes to tax forms, tax reporting in the United States, and innocent errors of the past that are not to be repeated, the obligation of tax preparers in the United States is not the same as everywhere else. It doesn't require you to make the client go back and correct. Okay, and that's in some sense that's up to the client. You can't help them to do things going forward that you know or suspect are not correct. The advice about what to do about the past is advice in the client's interest, as to that relates to things like the potential increasing exposure that they have from interest and penalties from the old error. And if they go back and voluntarily raise their hand and correct it now, they're not going to go to jail. Oh, thank you. I just lost my presentation. Was somebody able to take that off? That's great. Thank you.
Yeah, we did that. We did that on this side.
I wish I could see our audience as well. But the IRS is so under-resourced at this time that, and of course, it's still a more effective tax authority than in many nations, but people will consider whether to just start reporting correctly going forward and not necessarily go back and that's not always an easy question to decide how to advise a client on, but in circumstances is not necessarily illegal to have that discussion. Where we're not right now in the United States, as we are in England and other of our practicing jurisdictions, is we don't have duties to violate the attorney-client privilege and rat out our clients.
Well, it is to rat out, right? If you tell me something that I cannot hear, I will have to tell somebody.
Yeah, the Enablers Act will include things like suspicious activity report obligations on additional of us intermediaries in the United States or advisors. And so that will change the nature of how we review the past. One of the things that we can't do is we can't commit, none of us should bother jeopardizing our livelihoods for the sake of assisting with laundering anything that is illicit or the product of, unlawful tax evasion. And that time is long past. So you have you have a difficult situation at times as to how to address that. But source of funds is the most difficult subject these days, I think, in the category of things you've just raised. And it's, how far to press the diligence. I mean, right now, I'm having a heck of a time getting clients that I've known for 20 and 30 years, and I know everything about their affairs for a long time. I know their source of funds, but they're asking, trustees are asking us to prove how the family made their money in coffee back in 1850.
Yeah.
And, it's very difficult to go back and provide, and trustees are seeking, to ask for evidence-based, as they are required to do, source of funds information for people that have been wealthy for generations is quite difficult. So.
Ivan, for us Brazilians, we have a full disclosure of all information and reports before the tax authorities and Brazilian Central Bank, etc. So this premise is quite common for us. And we've been facing during the last years many different interpretations over the concepts of CRS. It's pretty clear that the purpose of this act is not to share information with other jurisdictions. So do you think that in practical terms, this is something much more connected to an onboard of a client like a KYC with huge penalties, and in practical terms will just increase the services and the costs of the structures involving the US? Or do you think there is any other aspect that for us we should consider?
Good question. I mean, I think the way I would answer it is to say, I don't think, the US has been experiencing something of a, of a golden age in terms of having comparative advantage as a place for international wealth structuring, private wealth structuring. And the reasons for that are not because it harbors tax criminals. The reasons for that are that we have a very liberal trust law. We have 50 states that compete jurisdictionally for competitive, trust practice. And we have a tax system that is related to our overall economic system, invites the world's wealth in and gives it, a liberal way to invest and use our professionals. So things like mind and management, not creating taxation in the United States, not taxing capital gains of foreign investors and those kind of things, and leaving investment markets. But overarching all of this is still a culture that is more libertarian in terms of the sanctity of privacy as a domestic culture than is currently. So the competing force against, when I say the Enablers Act's probably not going to get passed in the Senate, it's because, as more than 50 senators are going to be influenced by people who say that would be terrible.
Okay.
Hard to believe. But the ethos in the United States is, is very strongly for privacy. So I think, and you see pushback in Europe. I mean, CRS on the one hand, on the other hand, the European rights of privacy are now beginning to challenge whether some of that is actually fair to privacy interests in terms of public access and things like that. And so I think while that struggle will continue in all our nations, the US is likely to still be on the privacy end of the continuum. I'll put it that way. The other factor is we have the big bat. We don't have to share, right? As long we're the world's policeman, and we can get away with murder sometimes because we can impose these rules on other countries with respect to FATCA, for example, but we're not I would say that at this stage, it's not likely that we would enter into a lot of mutuality of obligations to for automatic exchange. So it's not the U.S. is, these rules are evidence the U.S. is battening down the hatches. It's not going to be a place for thieves and cheats, but at the same time, I think hopefully there will still be more attractiveness to the U.S. privacy regime than a lot of other places. We're not going to adopt CRS, I don't believe. Anyway.
Yeah. And on top of privacy and not adopting CRS, what inspired CRS was FATCA, and to a certain extent. And when it started, and if you can tell us how FATCA is, what's the repercussions of FATCA? Because if I'm not mistaken, any individual with more than $10,000 would be reportable by FATCA to their countries with expectation to receive information on American citizens or people abroad. It's been almost 8 years of FATCA. What has come of that? What kind of, do we have any material information, the success or failures on that project that started all this, and started with the Patriot Act, but do we have any information on the success that this project has achieved?
There's not a lot. I don't have a lot to offer on that. I mean, the fundamental gap here to understand is FATCA is set up to have reporting on U.S. substantial owners of things. So the information that FATCA collects is about U.S. people. Even though it's capable of exchange, it's not really collecting information about people from other countries as a primary purpose or effect. So you can talk about IGAs and things, but we're not collecting through that process. We're not, you have to be a 10% or greater US, owner and that sort of stuff, right? So we're focused, FATCA is focused on collecting information on our people, our taxpayers. And so the impact of that information, even if it's, becomes more suitably exchanged, exchanged with discernment to find things that are of use. There's not a lot of use in foreign countries for the information that FATCA is drawing into the United States. Does that make sense?
To a point, but the fear that we had in Brazil was, well, we're going to receive the report from the U.S. and say that Mr. Jose, whatever, has a bank account that is not on his Brazilian income tax returns, because the Brazilian income tax return is just not on income, is also on assets held by the individual. So that's what was one of the biggest fears that we had here in Brazil in reference to the practicalities of FATCA. And,
we collect that information. We collect more information about bank accounts and FBARs and all kinds of things that we do collect, but that's not the same thing as FATCA.
And Ivan, just to make clear for myself, regarding the current structures that we have involving these entities in US, as from January 1st, 2025, we will have the obligation to report. So we need to review all those structures in order to identify what will be subject to this report. Is this understanding right?
As of January 1, 2024, you're going to have to do this compliance with respect to new companies within 30 days of the registration.
But for the older ones, it's 25.
To the back, yeah.
Okay.
Yeah.
Okay. Do we have any questions from the audience, Norberto?
Yeah, I was checking here. We covered all the topics in our individual comments. So I believe we have covered, and I think we should ask Ivan if he has any questions in reference to Brazil. Don't ask who's going to win the election. Anybody that tells you either way will not be a reliable answer. And the only reliable answer that you can get from Brazil is that there's volatility ahead from us.
Well, I hope you have an honest and fair election, and the results are respected, and there's peace. And I wish you all the best. We have, both our countries have such volatile politics these days, and it's hard to read what's coming next.
Have to maintain freedom of speech, which is something that we should hold dear. And there's some many other things happening that makes us kind of put different weights on the same scale. So it is the challenge that we have at the moment.
Yeah.
So I'm here looking at our chat on YouTube. We don't have any further comments. I want to start by thanking you so much for being available this early morning in New York to be talking with us and covering about the changes that are happening in the US. And I want to pass it along to you two for final considerations for today.
Well, thank you. Again, it's a pleasure. I'm sure there's a bunch of friends peeping in here from Brazil, but I can't see who they are. And in addition to you two friends. So thank you for your time. And I hope this was, informative. I hope I'll see you in Brazil again soon.
Thank you very much, Ivan.
Okay, take care.
Bom, agradeço a todos da nossa audiência pela participação, pelas perguntas. Mais uma vez agradecer ao Ivan e a todos vocês, e até a próxima reunião do STEP Brasil em novembro. Muito obrigado, pessoal. Thank you, Ivan. See you. Bye-bye.
Hey, obrigado.